Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about conflicts of interest in policing. Cases that should have gone to the Supreme Court of Canada, but didn't. Kyla Lee was a police officer who was charged with a number of offenses related to allegations that he had essentially provided confidential policing information to bad people. In the course of the investigation, the police force that he was employed with, the London Police Service, initially conducted the investigation against him. But before charges were laid, they turned over all of the information from the investigation to the Ontario Police and asked them to take over the investigation. At trial, Mr. Corrado argued that there was a conflict of interest and an abuse of process by his own police agency investigating him, and that this should lead to a finding that there was an unfairness in the process that should have his charges thrown out. The court disagreed. He sought leave to the Supreme Court of Canada, and the Supreme Court of Canada denied leave. And this is an important case because, as we see across Canada all the time, there are investigations of police officers engaging in misconduct. And in cases where police officers are allegedly engaging in misconduct, it usually comes to the attention of the police agency that they're working for. It would be helpful for the Supreme Court of Canada to delineate guidelines as to when a police agency alerted to possible misconduct or possible criminal activity by one of its own members should require an outside police agency to start an investigation. What is the threshold that should be applied in determining when an investigative body should stop investigating one of its own members and bring in an outside agency? Knowing where that line should be drawn would prevent other cases from going forward in the future where there were arguments that there were conflicts of interest and abuse of process. And also knowing where that bright line is supposed to be drawn can help inform police agencies in conducting these investigations and may also assist in weeding out individuals who are investigated by their own policing body but then who are not charged, or where the evidence is not properly gathered because the conflict of interest operates in favor of the person who's working for the police agency as opposed to against it, like Mr. Corrado was arguing. Unfortunately, it's going to take another case for the Supreme Court of Canada to recognize the significance of this issue in how police conduct investigations of their own members to ensure the integrity of police investigations across Canada and the integrity of police officers who are potentially engaging in criminal conduct. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.